Welcome to Gas, the true story of a toxic train derailment. I'm Ron Scholl. Last time on Gas, we briefly looked at the three cases to go to trial over the Alberton spill and considered the issue of liability for the derailment, which Montana Rail Link vigorously denies. We now continue with Part 6, Chapter 11, Discovery Wars. Epigraph. As the deposition ran on, Potter quipped, "We've got light at the end of the tunnel here." Dunn. "It may be another train." Potter. "Always is." From the deposition of Ronald Dunn. Schleep v. MRL almost became the first case at trial, slated for May 4, 1998. A neighbor of Lucinda Hodges 2 doors down, Susan Schleep abandoned Alberton soon after re-entry. Schleep and her daughter were represented by the Great Falls firm of Hoyt and Blewett. A few weeks prior to trial date, the case made the front page when U.S. District Judge Don Malloy sanctioned MRL for knowingly withholding from discovery Roadmaster and Track Inspector documents about Curve 155 railware and a key memorandum from Chief Engineer Richard Keller pertaining to MRL's track maintenance. The Missoulian belatedly ran the story a week after the order, their only coverage of the Schleep case. The news flashed across the wire while Hodges pleaded for Alberton victims in Senator Max Baucus's D.C. office that spring. MRL also withheld correspondence between Keller and Stephen Riley of TSL, the second lab that tested rail fragments in 1996. MRL only produced all these documents a week after Keller mentioned them during his deposition in February 1998, the day before the discovery cutoff date. Lead attorney Randy Cox said he hadn't seen railware documents pertaining to Curve 155 until Keller produced them 4 days before his deposition, and Cox later sent them to attorney Xander Blewett, but only after plaintiff's rail expert Ronald Dunn had been deposed. As for the Keller-Riley letters, which were also part of the FRA file, Cox originally argued in 1997 that these were precluded from discovery as FRA investigative materials. MRL argued throughout their cases that all FRA accident or incident reports, injury reports, rail assessment reports, safety reports, internal memos and letters, everything FRA, were inadmissible by virtue of the FRA document stamp citing the regulations stating, "No part of an accident incident report may be used in a civil action for damages." This preclusion allowed the government to gather candid information to benefit public safety. All FRA documents at issue in Schleep bore the exclusion stamp, which seemed automatic, doubling as an imprimatur of clerical reception. Malloy had earlier ordered only 7 of 18 FRA documents excluded as evidence, ruling that the regulatory language did not extend to FRA-held documents that did not pertain to accident or incident reports. He and future judges ruled admissible documents such as the CF&I and TSL rail reports and the Keller-Riley letters. MRL fought to exclude such documents for years to come. In August 1997, Malloy ordered these documents discoverable and ordered Cox to produce them. But later, Cox still hadn't produced the Keller-Riley letters, having assumed the plaintiffs would request the letters through a FOIA, a Freedom of Information Act request, to the FRA. In April 1998, Malloy would have none of it. He wrote, "It is difficult to understand why the railroad would believe evidence about rail condition in a suit about a derailment would not be desired and highly relevant to both the claims and a proper analysis of the defense." MRL had violated the federal rules of initial and continuing disclosure. Malloy also noted evasiveness in MRL's answers to discovery interrogatories. Malloy ordered that MRL produce any communications between attorney David Potter, Cox, and Keller for the court to inspect, that the plaintiffs could continue to make discovery requests and depose witnesses, and that Potter could assist Cox at trial but could not question witnesses or present argument to the court. Potter, an articulate and persuasive speaker, had been gagged. Potter had deposed plaintiff rail expert Dunn and calculatedly steered the deposition toward obtaining an opinion from Dunn that the vertical split head was caused by inclusions in the rail, Malloy wrote, which Riley had not concluded. But Potter must have known of the Keller correspondence with Riley, if not the railware documents, and maneuvered Dunn into an unequivocal position Potter knew was not supported by the evidence, Malloy said, rendering Dunn useless. Malloy struck from the record the deposition of Dunn, allowing him to be redeposed. Finally, railware in the Alberton derailment made local news. Malloy ordered that it would be presented as a fact to the jury that 3 months before the crash, the ball or top of 1,247 feet of rail in curve 155 was, quote, worn out, and that by February 1996, all of MRL territories had locations, sometimes entire curves, with rail worn below MRL standards. MRL got off easy, as the plaintiffs had sought the ultimate sanction of precluding MRL from presenting its theory of defense that argued against worn rail as a cause of the derailment. The art of winning unfairly had been dealt a setback. MRL's liability defense faced a serious threat. TSL's Riley concluded that railware played a major role in the development of the vertical split head. Railware cried liability. In September 1996, a month after the TSL report, Keller wrote Riley, "I talked to the FRA and they want me to talk to you about it. First, you did not perform a structural analysis of the rail fragments to determine the structural capacity of the rail to better determine how wear affected the internal strength." Keller also questioned whether the examined rail even held the origin of the VSH, as Riley had thought. MRL sought to discredit rail wear as a factor while raising the possibility that unrecovered rail with inclusions might have caused the VSH. Riley wrote back, reiterating that measurable wear was appreciable, but he agreed that a structural assessment of rail wear would add more information, and that another VSH origin related to inclusions may yet exist. He said, "Given the incomplete set of data, we believe that the combination of service wear and possible inclusion levels had led to the VSH, and then, most likely, caused the derailment." Possible inclusion levels would play no small part in the MRL defense, which goal was to shift blame from MRL operations and maintenance to the rail itself. Attorney Blewett sought to nail MRL on liability in order to seek punitive damages, and named BN, Burlington Northern, as a co-defendant. Schleep contended that Susan Schleep and her young daughter suffered chronic breathing problems and possible brain damage. Less than 2 weeks after the rail document sanctions, Schleep was settled. Blewett was next retained by Missoula attorney William Rossbach, who likewise sought punitive damages, including in a class action suit. Mayo et al. V. MRL et al. Established the liability theories. MRL's primary legal firm was Desopoulos, McDonald, and Lind of Missoula, which hired Randy Cox of Boone, Carlberg, and Hayden, also of Missoula, and David Potter of Minneapolis. Ronald McDonald, corporate counsel for MRL, established Cox as the lead counsel with control of most everyday issues, such as producing documents. Potter would cover specifics, such as rail science. Blewett had agreed not to further use Malloy's sanction order after MRL belatedly produced documents, but upon discovery of yet more documents in Mayo, Blewett complained, "Plaintiffs wouldn't have agreed not to use Malloy's order if they'd seen these documents." The Rao documents regarding rail recovery were produced only after Schleep was settled. "I realized that we had a problem with documents sort of showing up," Cox admitted in an understatement. As a result, MRL employee Marty Rao was now an important witness. In fact, Rao led the effort to recover, inventory, and store the damaged rail, and no plaintiff lawyer had been aware of this until nearly 3 years after the derailment. In Mayo, MRL wanted Potter back in full force as co-counsel, and a hearing was set to determine whether Potter knew of the Keller-Riley letters when deposing Dunn, which Judge Malloy had assumed. The unusual hearing in February 1999 saw MRL corporate counsel McDonald pitted against Blewett with Cox and Potter as witnesses. Potter now admitted being aware of the Keller-Riley letters, but claimed, again, they were inadmissible as FRA documents anyway. Furthermore, he felt the letters were exculpatory evidence because Riley's response partially adopted Keller's criticism. Why would he hide them? But Blewett suspected MRL attorneys maneuvered Keller's inquiries because they needed to discredit Riley's original conclusion about railware. In his 1999 deposition, Keller disavowed having technical knowledge regarding points his letter raised and said the letter was based on MRL's expert legal advice. MRL even argued Keller's letter to Riley was inadmissible evidence as a public FRA accident investigation-related document, while the drafts were totally out of bounds as privately privileged. While MRL sought to keep evidence of railware from a jury, plaintiffs believe MRL's defense evolved from the letter Kelly sent Riley on behalf of MRL. MRL next sought to bring Stephen Riley over to their side to have him discredit his own original damning conclusions. MRL hired Riley in June 1998 at Mid-States Analytical Lab in Oklahoma after Riley left TSL. At TSL, Riley had examined 9 fragments and determined that N33, North Fragment number 33, was the origin for the vertical split head. He reported that wear was a major factor and inclusions, though detectable, played no part. At the Mid-States lab, Riley came to new conclusions as a paid examiner for MRL. He now referred to N33 as having a so-called non-bonded area and claimed that this area of the rail was never metallurgically sound, a stark reversal of his original conclusion for the FRA. With this pronouncement of unsound rail quality, MRL reversed itself and claimed N33 was the origin of the VSH after all. Riley also backtracked on the contribution of wear. The vertical wear he had cited was about 0.03 inches above MRL's relay standard. The gauge wear was exactly at MRL's relay standard. Riley did not perform a load or stress analysis of the worn rail as Keller had suggested, but now used that uncertainty to proclaim, "Without such analysis nor without knowledge of true track conditions at the time of the incident, I am not able to reach a detailed opinion on the degree to which rail wear played a role, if any, in the inclusion-induced fracture I identified in the MRL rail," he said. It wasn't so much that Riley was now on board with the MRL defense, but his new statement basically retracted the independent TSL assessment that could hurt MRL in court. It appeared MRL wanted to use his new testing as an extension of the original FRA requested testing and use him as a factual witness, in effect rebutting his own earlier factual findings. Plaintiffs argued the FRA did not request any follow-up test. In his deposition, Riley admitted that the unsworn statement of Stephen R. Riley was drafted by an MRL attorney at MRL's suggestion and given to Riley to sign. In Mayo, Magistrate Erickson ruled to exclude MRL from introducing improper opinion testimony solicited of Riley or to treat him as an expert witness. In December 1999, with the Mayo trial looming, Magistrate Erickson denied MRL's motion to exclude reference to any wrongdoing in the Schlepp discovery to the extent that it might be probative in assessing punitive damages. If a case could be made for punitive damages, Schlepp sanctions were in. Plaintiffs sought new sanctions, arguing there is substantial evidence the defendant MRL knew of the existence and contents of the Rao-Keller documents and knowingly withheld the documents. In January 2000, Erickson denied the motion for new sanctions, ruling that the Rao documents pertain to routine maintenance and other rail locations. But the Rao documents were in fact much more. Mayo settled soon after. In State District Court in Griffin et al. In 2000, Judge Ed McLean granted MRL's motion to strike the Malloy order from the record. No jury would ever hear of the railware sanctions from Schlepp. The Rao documents were not discovered by plaintiffs until early 1999 during Mayo, when MRL produced a large number of documents en masse. Mayo plaintiffs argued that MRL hid Rao's involvement for over 2 years, even from their own counsel. In 1996, MRL had great incentive to quickly investigate the cause of the derailment, even as they manipulated federal response. On April 11, NTSB's Dave Watson arrived in Missoula to investigate. Ken Holgart of the FRA said Watson was initially stonewalled at visiting the site up close. They kind of talked Dave out of it, he said. Watson was certified in hazmat. Meanwhile, MRL and its contractors freely roamed the site, at times without protection. The log suggested that the earliest any federal agency got near the point of derailment was April 14, when the tech group announced, "We have negotiated an entry plan for the NTSB, the EPA, and the Coast Guard." Investigators from the NTSB and FRA made only one site trip each during the 17-day evacuation, and only hazmat-certified Dave Watson got close to the point of derailment near the tanks. Watson only marked observable rail for recovery. Ideally, Watson would have laid rail out for a reconstruction himself, but the area was contaminated. When Watson left the Alberton area by April 18 or 19, he had not removed or inventoried any rail fragments. MRL announced on April 21 that crews recently discovered a 3-foot section of track with a horizontal crack on its side. Ultimately, not all of the rail was recovered. Plaintiffs claimed MRL attorneys created the illusion that rail recovery after reentry was exclusively controlled by the federal government. In his affidavit, Cox said the NTSB and FRA, rather than MRL, were responsible for rail recovery efforts. It was the NTSB and FRA that did not find 60 to 70 feet of rail, an evolving number, after the derailment, Cox said. Plaintiffs argued MRL was an active partner in the investigation of the derailment. Main investigator Lee Klaus of the FRA concurred that the FRA and MRL had a cooperative effort. After April 28's general reentry, Klaus helped Rao collect rail. Klaus said Rao was pretty much in charge of making the marks and developing a plan of the recovery of the rail and the nomenclature of the rail for identification, and diagramming a reconstruction. In sum, Rao recovered and received from workers, inventoried, reconstructed, and stored the rail. The FRA mainly just received rail pieces from MRL for examination. Only Rao kept a record, the Rao documents. Klaus left the area on May 9, and Rao continued to recover rail but did not report his later findings to Klaus. Later, Chief Engineer Richard Keller decided who would test rail and which pieces. As for unrecovered rail, Dave Watson of the NTSB said that not finding all displaced rail for a complete reconstruction was common in his experience following a major derailment. However, Klaus said he found much of the Curve 155 North rail fragmented but not scattered. MRL Roadmaster Roger Babcock didn't believe missing rail still lay somewhere on site under dirt. "I would say no," he testified, "because all that's been pretty well dug out." So, where did the missing rail go? Only North High Rail, the failed side, went missing. Plaintiff expert Ronald Dunn wasn't impressed by the federal investigators and questioned why Watson had the Fox, MRL, gather critical data in the henhouse, he said. "Some people have made the analogy to a crime scene, EPA Ombudsman Robert Martin later said. Would you let an alleged murderer go to a crime scene and monkey with it for a few days and then take evidence?" Mayo plaintiffs alleged MRL hid from its counsel and any litigants for over 2 years the fact that it had a management-level employee recovering rail, attempting to reconstruct the rail from this derailment, and creating notes from his work. Additionally, Rao's notes and other withheld documents were the only documents that reflected the extent of A-rail involved. A-rail held much significance for plaintiffs, considered by many people to be inferior grade, not suitable for curves. It was unclear when Rao first started collecting rail. One piece would be key, the failed rail, originally 39 feet long and containing some length of a vertical split head, or VSH. MRL's crews were instructed to look out for suspicious-looking rail, and apparently they cut fragment N19, a rail piece with a vertical split head, on April 21, from the mangled track so supervisors could examine it. After re-entry, Rao began his rail recovery documentation. Rao's May 9, 1996 memo included a hand-drawn map of rail pieces as I found them May 6, 7, and 8, he said. Measurements were taken by FRA's Lee Klaus. A list of the recovered displaced north rail totaled 507 feet. 606 feet of temporary panels were put on the track, so 99 feet of the north rail were originally not accounted for. The failed rail was particularly shattered into fragments. Rao noted many north rail pieces as inferior grade A rail. In a May 13 letter to CF&I, to whom Keller first sent rail for testing, he mentioned a heat number off an A rail segment. In a June 26 letter to Keller, Rao said he continued to find rail since my last report of May 9, 1996, he wrote. This added 45 feet to a total now of 552 feet of recovered north rail. FRA's Klaus was surprised that Rao had continued to look for and found more rail. He thought the area had been thoroughly inspected, and no one subsequently told him about the, quote, new finds or where they were discovered. He said he never saw a piece that showed the origin point of the vertical split head. N33, later identified by TSL's Riley as the origin piece, had already been found, so Klaus apparently had not believed it showed the origin. An undated MRL document on recovered rail inventoried 40 main pieces of north rail, N1 through N40, ranging in size from less than 1 inch to 99 feet. Rail sticks were welded for 565.5 feet total. By Rao's tally in the fall of 1996, about 40 feet of displaced north rail had not been recovered. In its final report of 2000, plaintiff expert Dunn said 35.5 feet of north rail was never found. None of these MRL rail inventory documents were produced until after the 1998 Schlepp settlement. To plaintiffs, the belated discovery of Rao documents and the evidence of A-rail, on top of the belated discovery of the railware documents on Curve 155 and the Keller-Riley letters, suggested MRL had something to hide. In tandem with the claim that MRL purposely hid crucial documents and Judge Malloy's sanctions, plaintiffs suspected MRL tampered with physical evidence. In addition to missing rail, some recovered fragments of the failed rail were subsequently lost after MRL testing. No plaintiff expert ever saw two pieces lost separately in transit via UPS. In total, at least 1 foot 9.5 inches was lost as 3 pieces following MRL-directed testing. These lost pieces were important because fragment ends could be matched up with another fragment, perhaps one with an identifying heat stamp. Lost and missing pieces precluded plaintiffs from matching everything in a reconstruction of the 39-foot failed rail. Additionally, Rao reported that 4 formerly recovered pieces totaling 20 feet, N5, N34, N35, and N38, went missing by the fall of 1996, apparently prior to going into a storage warehouse. N38 had a VSH and was discovered missing as Rao prepared to send it to TSL for testing. Plaintiffs claimed MRL lost custody of the 4 pieces by leaving them in areas known to be frequented by the public. Some of this rail went missing from the side of the road near the derailment site prior to storage, left unsecured, and then some apparently later from the warehouse. Still later, N55 went missing as well. But a major plaintiff concern was that Keller testified he noted an A-rail heat number on a rail fragment with a VSH. Presumably, only one rail had a vertical split head, the failed rail. A-rail was typically inferior grade. Male plaintiffs claimed this piece, seen in Keller's office by FRA investigator Lee Klaus, was N19 before it was further cut up. Proof of N19 being A-rail apparently disappeared because all surviving fragments with a VSH had no heat number. Notably, the failed rail was the only displaced rail whose recovered fragments lacked any of the several identification stamps that were put on each 39-foot rail. In his deposition, Klaus said one, possibly two of the pieces of rail he examined that contained a VSH were positively identified as A rail. Since N19, 31, 32, 33, 38, and 39 were the only recovered pieces with a VSH, plaintiffs said, one or more of these pieces of rail either bore a heat number, which heat number was later cut off, or was determined by MRL to match a piece of rail bearing a heat number identifying it as A rail. Plaintiff attorneys clearly felt MRL was hiding evidence that the failed rail was A rail. Meanwhile, MRL simply countered there was no direct evidence the above-mentioned pieces were A rail because none had a heat stamp, at least not when plaintiff experts saw them. In sum, male plaintiffs accused MRL of destroying, losing, or hiding rail in an attempt to shield itself from liability. Magistrate Erickson ruled in January 2000, since there is at least prima facie evidence that MRL employees had in their control relevant pieces of track, including a piece bearing a heat stamp indicating it was A rail, which subsequently has not been found, that seems fair game for comment under the conception of negligent spoliation. Mayo settled that month. Prior to Mayo settling, plaintiffs claimed that despite preparing almost immediately for litigation, MRL proceeded to lose or destroy important evidence, including the piece of VSH rail with a heat number, video taken of the rail and derailment site, and digital pictures taken of the rail, and deceptively withheld documents about Curve 155's rail. About 31 to 36 feet of displaced north rail was never officially recovered. Most important, though, was the Keller rail, the piece with a vertical split head and identified as A rail by the FRA's Klaus in Keller's office. This evidence fell into its own unique category of ghost rail. After the discovery wars came the fight over evidence that survived to the light of day. The shattered length of steel and the story it had to tell was invaluable. Next time on Gas, the true story of a toxic train derailment. Plaintiffs build the case that Montana Rail Link has run an unsafe railroad for many years, culminating in increased accidents and failed rail leading up to the Alberton spill. MRL dismisses the accusations as a junk railroad conspiracy theory. We also consider the recent history of Curve 155 inspections. Until then, this is Ron Scholl. Thanks for listening. This podcast is adapted from the book Gas, the true story of a toxic train derailment. Visit Amazon.com to see the two-book series. To access support material in the book, such as maps, photos, illustrations, and video links, visit my Facebook page Gas, the true story, or watch my Gas playlist on my YouTube channel at RL Scholl.